One of the big problems between separating tort law and climate change is that fundamentally, tort law is a private law system of law. It's very much focused on providing remedies to individuals. That doesn't necessarily make it all that well suited to accommodate something that affects literally everybody, like climate change. So we've got a number of doctrinal barriers which are really difficult for us to overcome if we're looking at using tort law as a response to climate change. Some that have been particularly challenging are just questions around who's the plaintiff and who's the defendant. So with something like climate change, we're all contributing to global warming and climate change, if nothing else than through our consumption of things like fossil fuel dependent resources. We're also all suffering the effects. Now, of course, one of the issues is that those effects aren't being borne uniformly across all of us. So that leads to lots and lots of doctrinal challenges around things like, well, who is it that should be liable? How do we apportion liability if we've got many, many people who are contributing to it? And how do we distribute those remedies evenly to reflect the harms that are suffered by everybody, but not necessarily to the same extent?